Good afternoon. Welcome to the Lauterpacht Center Friday Lunchtime lecture. It's my great pleasure to introduce our speaker, Dr. Arman Sarvarian, who is Reader in International Law at the University of Surrey. Dr. Sarvarian is a generalist in the best sense of the word and the best sense of the tradition. The breadth of his interest is reflected in an enviable record of publication on topics such as professional ethics, the law and practice of international courts and tribunals, state responsibility, territorial disputes, investment law, and state succession. And his most recent project, I believe, is on the law of climate change. His experience as a practitioner is no less wide-ranging. So Arman has represented ARMI in the legal committee of the General Assembly. He has served as an ad hoc judge at the European Court of Human Rights. He acted as counsel in investment dispute. Most recently appeared in the ICJ on behalf of Côte d'Ivoire in the climate change advisory proceedings. Arman's first book, Professional Ethics at the International Bar, was published by OUP, and it's unquestionably the leading text on the topic. His latest book, also published by OUP recently, on the law of state succession, is the product of 7 years of deep learning, hard graft, I dare say, on the topic of state succession, which of course is central and of structural importance to the international system and to our discipline. I'm hoping that Arman will be able to synthesize some of his insights and findings in the next 40 minutes, after which we'll have some time for questions. So Arman, the floor is yours.
The title, The Law, State Succession, Principles and Practice, begs several questions. Chief amongst them is whether there can be a law in a unitary sense with cohesive principles at all. Far be it from me to spoil the suspense. At the outset of the project, the received literature from the desovietization period tended rather to emphasize a chaotic, confused, contradictory character. In the latest edition of Schroer's commentary on the ICSID Convention, published in 2022, Stefan Schill noted, quote, "The legal framework under general international law relating to state succession is unsettled and highly controversial, with one approach favoring, as a matter of international law and policy, continuity of treaty obligations, and one departing from the principle that new states should start from a clean slate. In addition, state practice in respect of state succession is characterized by what has been described as situation-specific diplomatic bricolage. One major attempt at codification, the 1978 Vienna Convention on Possession of States in respect of treaties, was largely unsuccessful and only in part reflects customary international law. Much will therefore depend on the circumstances of the succession in question," end quote. In the past decade, there have been rendered no fewer than 7 investor-state arbitral awards and set-aside judgments featuring succession to state property, nationality, and bilateral investment treaties. In recent months, succession to territorial rights has also featured in argument before the International Court of Justice in the pending Land and Maritime Delimitation and Sovereignty over Islands case, Gabon versus Equatorial Guinea, and might well also be invoked in the next phase of the pending arbitral award of 3rd of October 1899 case, Guyana versus Venezuela. The renewed importance of the field in diplomatic settlement notwithstanding, it was quite possible to conclude in this work that the emphasis should be placed upon the word practice. Whereas there might well exist a clutch or smattering of accepted rules as attachments or annexes to the law of treaties, the law of nationality, and other fields perhaps, the mass was insufficiently coherent to constitute a law unto itself. Though perhaps unlikely to find that the practice was insufficiently cohesive to sustain any principles whatsoever, the existence of a unitary law in its own right was far from plain on the basis of the received doctrine. From the coining of the term succession of states by Johann Caspar Lunchtime in 1868, the existence of a field of general international law gradually won general acceptance in classical doctrine. Whilst much of this literature featured the construction of grand theory rather than empiricism, it also received its own chapter in practical works, treating closely with 19th century state practice, such as the first editions of John Bassett Moore's A Digest of International Law in 1902 and Lasse Oppenheim's International Law in 1908. In the wake of the many transfers of territory arising from the great peace treaties of the Great War, hundreds upon hundreds of interstate arbitrations and decisions of national courts in the 1920s and 1930s dealt with myriad problems of state succession. Some decades before the creation of the reports of international arbitral awards under the aegis of the United Nations, a great many of these important decisions were painstakingly collected, translated, and digested in the venerable Annual Digest of Public International Law Cases, later the International Law Reports, initially under the joint editorship of Sir John Fisher Williams and Dr. Hirsch Lauterpacht, as he then was, and later to be edited by Lauterpacht Senior alone. Arranged by subject matter, its very first volume, published in 1929, and digesting judgments and awards rendered from 1919, featured dozens of decisions on the succession of states. While permanent courts of international justice had far less occasion to pronounce upon the field than did national courts, mixed arbitral tribunals, and interstate arbitral tribunals, its decisions on post-war settlements, notably the certain German interests in Upper Silesia case and the acquisition of Polish nationality case, had considerably more to say on a law of state succession than has any pronouncement of its successor. Alongside other problems connected to the late war, such as neutrality, naval warfare, the new mandate system, and the protection of minorities, it is no exaggeration to state that much of the attention of international lawyers in the interwar period, for example, in the pages of the recently founded American Journal of International Law and British Yearbook of International Law, was devoted to dealing with problems arising from these territorial changes. In the first decade of the Record de Cours of the Hague Academy of International Law, no fewer than 12 extended lectures treated with succession to state debt, nationality, territorial obligations, private rights, and so forth. The particular difficulties to have arisen concerning the effects of a succession of private persons prompted the inclusion of the question of the private property of aliens, the so-called doctrine of acquired rights, in the agenda of the embryonic League of Nations Codification Conference in the year 1930. When Professor Hirsch Lauterpacht, as he had by then become, submitted his famous memorandum on a general syllabus for the International Law Commission in 1949, he included the subtopic Succession of States and Governments in the second major topic entitled States in International Law. Taking up the subject, he wrote, quote, "The question of state succession, even more than that of recognition, has so far remained outside the work of codification. One possible explanation of this fact is that state succession has often been regarded as a problem arising primarily as a result of war, and that, as such, it ought, like the law of war unto itself, to remain outside the field of codification. This view is open to question. Experience has demonstrated that changes of sovereignty may take place in ways other than the liquidation of the aftermath of war, as has been shown, for instance, by the questions of state succession, which have arisen as the result of the emergence of the independent states of India and Pakistan," end quote. Having given priority to other topics in the general syllabus, notably the law of treaties, the International Law Commission did not come to the matter of succession of states and governments until its appointment of Professor Manfred Lux, as he then was, as Special Rapporteur in 1963. While the local treaties project, culminating in the successful UN Diplomatic Conference of Vienna in 1968, undoubtedly remained the leading priority of the Commission, the gathering and mounting pace of decolonization had infused the topic of state succession with a certain urgency for many of a rapidly expanding membership of the United Nations. While several commonly accepted instances of decolonization, such as the accession to independence of Jordan in 1935, the secession of the Philippines in 1945, and the secession of Libya in 1951, had taken place earlier, the year 1960 was a pivotal one in which dozens of successions took place in rapid succession, notably the dismantling of much of the Third French Empire and the delivery by Harold Macmillan of his famous Winds of Change speech. Preoccupying as it was with the Law of Treaties project to prove the concept of codification, scant progress was made on the item by the time of the election of Professor Lux to the International Court of Justice in 1966. At the end of one fateful week in 1963, however, a subcommission under his chairmanship encountered such deep disagreement on the nature of state succession that it decided to abandon its debate altogether. Rather, it proposed to split the topic into two projects, one on succession of states in respect of treaties, and the other on succession of states in respect of rights and duties resulting from sources other than treaties, to be led by two professional rapporteurs working in parallel. Following the successful first session of the UN Diplomatic Conference at Vienna in 1968, the Commission immediately appointed Sir Humphrey Wardock, who had been the fourth and final Special Rapporteur for the Law of Treaties project, as the first Special Rapporteur for succession to treaties. It also decided that that project would be given priority. At the same time, it appointed Professor Mohamed Bejawi, as he then was, as Special Rapporteur for the second project, with a mandate to elaborate a preparatory study on the diverse and complex topic of state succession to everything but treaties. In his manual opus entitled State Succession in Municipal Law and International Law, published mere months before the commencement of the two projects of the Commission in 1967, Professor Daniel Patrick O'Connell saw the existence of a body of law known as state succession to be so evident that he did not consider it to be necessary to justify its unitary character. Similarly, Professor Karl Zemanek had assumed the existence of a cohesive field of general international law in his Hague Academy lectures of 1965. While the International Court of Justice had scant occasion to consider the subject in its early decisions, the voluminous post-war succession agreements and jurisprudence of national courts and interstate arbitral tribunals cast scant doubt upon the existence of a unitary law on state succession in its own right. The decision of the International Law Commission to split the topic had been motivated by its scale and complexity, as well as the difficulty that its subcommission had encountered in a general debate on theory. From the inception of the project, however, Wardock struggled to define the concept of state succession and opted to approach the topic as a doctrinal branch of the law of treaties, rather than a general law of succession. Quote, on the premise that neither the prevalent theories nor the existing practice offered a unified approach, end quote. Amidst disagreement, the International Law Commission adopted, as a neutral compromise, a modified version of Wardock's working definition of a succession of states in 1972. The following year, a different definition proposed by Bejawi for his project, premised on the observation that the definition adopted for succession treaties was fundamentally different, was put to one side by the Commission, which proceeded to apply the succession treaties definition to his project without explanation. While the definition of state succession merits extended treatment in its own right, it was the rock upon which the conceptual bark of the law founded in the codification enterprise. In adopting certain basic concepts for both projects, such as the date of succession, the International Law Commission strove to provide contracting states at the two UN diplomatic conferences with drafting consistency. Nevertheless, its decision to discard general debate on the very nature of state succession cast a shadow over its deliberations on the substance of the two projects time and again. In the wake of its decision to put to one side the, quote, extremely controversial, end quote, topic of so-called acquired rights in the second report of Bejawi, and instead to focus upon state property and debt for his project, the conceptual fragmentation of the field, some 20 years before the Commission was itself to make that term famous, was unwittingly achieved by arranging the field of state succession according to its parts rather than its sum. In 1978, the UN Diplomatic Conference adopted the Vienna Convention on Succession of States in respect of treaties. Far less successful than its more famous counterpart on the law of treaties, this codification convention has never been applied as designed. Still less has its sister treaty, the 1983 Vienna Convention on Succession of States in respect of state property, archives, and debts, which has yet to enter into force 40 years after its adoption. In a valiant attempt at progressive development, the 1999 ILC Articles on Nationality of Natural Persons in relation to state succession was not adopted, but noted and annexed by the General Assembly. This sparked a regrettable trend in its reception of ILC products that has only just been broken in its last session for the 2019 Articles on Crimes Against Humanity. Also in the last session, the Commission signaled its intention to conclude its project session in respect of state responsibility by adopting a final report explaining the problems that would be encountered if it were to continue work on it. Amidst this unhappy tale of brought attempts at codification on a topic on which, by some measures, the Commission has dedicated more space than to any other in the original Lauterpacht syllabus, the College of International Lawyers largely came to treat its work, in the words of O'Connell, quote, as so sacred that it could not be challenged, end quote. Despite his willing reception of the 1978 Vienna Convention on Succession of States in respect of treaties, scholarship on the subject during his period of resurgent interest in desovietization was principally preoccupied with petty codification against the facts, the title of the famous study of the Hague Academy of International Law, rather than identifying the law of state succession through study of state practice over the long term. As the late Professor James Crawford, as he then was, wrote in the year 1980, quote, suitable as it was for extended scholarly treatment of the sort O'Connell had given it, this topic of state succession was not self-evidently ripe for codification at the end of the 1960s, either intrinsically or as a matter of relative priority of importance. In itself, it is a rubric containing diverse, diffuse, and difficult issues, many of them solvable only by particular reference to the facts of individual cases. Codification was, at this time, likely to be influenced overwhelmingly by the recent experience of decolonization, an experience not necessarily typical of the cases of succession most likely to occur in future. Various administrative techniques had evolved for coping with discontinuities resulting from succession, and it was arguable that evolution should be allowed to continue undisturbed by attempts at formulating general rules, end quote. Relative to the other fields of state succession, scholarly interest during desovietization was overwhelmingly focused upon succession to treaties. Whilst this partially tracked the aforementioned anxiety about the status of the 1978 Vienna Convention, which finally entered into force in 1996 in the teeth of burgeoning desovietization practice, it also reflected the relative accessibility of data on state practice. A good deal of information concerning depository practice, and especially bilateral treaties, is obscure or otherwise difficult to obtain. Yet the logistical problems of research pale in comparison to the daunting challenges faced by students of state succession for state property and debt, nationality, private property, and so on. Given that succession to treaties is rarely prominent on the initial agenda of a successor, and succession to treaties has certain peculiar problems, such as the effect of various forms of unilateral declarations by successors, the overweening focus of the college on that aspect of state succession tended to foster a skewed image of the field as a whole, whether in terms of the treatment of succession matters by states or the relative importance to states of treaties, as opposed to state debt, for example. However, state practice traveled in a rather different direction. Even as the college largely focused on the relatively rare problems related to the cases of the Soviet Union, Czechoslovakia, and especially the Socialist Federal Republic of Yugoslavia, the tendency of state succession to produce a long half-life prompted a steady stream of practice during the desovietization period. Largely unremarked, questions from earlier, more obscure cases, for example, the resolution in the year 1980 of the disputes concerning the debts of the Free City of Danzig absorbed by Poland in 1945, alongside fresh cases of succession, such as the accessions to independence of Micronesia, the Marshall Islands, Namibia, and Palau between 1986 and 1994, alongside the secession of Eritrea in 1993, saw government lawyers, judges, and arbitrators devise pragmatic approaches that largely ignored the codification conventions. Far from approaching a succession of states in a piecemeal fashion, with rules of succession attaching to various rubrics, succession to treaties, state property, and debt, so on, state practice has featured a high degree of coherence in treating with a law of state succession as an integral field. During this period, the International Court of Justice, stayed on one issue in the Nagimaros project case, Hungary versus Slovakia, had little to say on the subject. In the words of Professor Andreas Zimmer, it, quote, avoided principled answers to questions of principle, end quote, on succession to treaties in particular, in the Bosnia genocide case, Bosnia-Herzegovina versus Serbia-Montenegro, and Croatia genocide case, Croatia versus Serbia. Ironically, it was through the medium of a procedural order that the court has arguably made its most notable contribution to the law in deciding that Serbia would remain as sole respondent in the Croatia genocide case following the secession of Montenegro in 2006. Even as the topic of state succession quietly dropped off the agenda of the college in the 2000s, save, however, for an excellent post-mortem on the attempt to codify succession to treaties by Matthew Craven in 2007, the half-life effect has continued to generate practice. This includes not only issues arising to the present day from decolonization cases, for example, the 2017 Sunak-Nantali judgment of the Court of Cassation of Italy on the succession of Mauritius to the 1873 Anglo-Italian extradition treaty, but also the more modern cases of the retrosections of Hong Kong in 1997 and Macau in 1999, alongside the secessions of Timor-Leste in 2002, Montenegro in 2006, as well as South Sudan in 2011. Though a field of general international law, the complex and fraught character of the law of state succession has, to employ a favored Crawford expression, paradoxically rendered it a specialist concern. Even as it has frequently flickered into irritable life in connection with abortive cases of succession, for example, the published memorandum written in 2012 by Crawford with the late Professor Alan Boyle, QC, concerning the abortive succession of Scotland, scholarly interest has largely been sustained by the field of investor-state arbitration, notably in the work of Professor Kristen Tams, Professor Patrick Dunbury, Dr. Daniel Costello, and Dr. James Devaney. Over the past 2 decades, encouraging signs from practice have showed a mounting willingness of counsel and arbitrators to disregard the texts of the International Law Commission in the absence of an empirical basis in state practice to prove their provisions. In none of the aforementioned investor-state arbitrations have those texts been treated with authority in the absence of the express and joint consent of the disputing parties, as partially occurred with respect to parts of Article 15 of the 1978 Vienna Convention on Moving Treaty Frontiers in Sanam, Laos, and Article 8 of the 1983 Vienna Convention in Lauterpacht and South Sudan. Rather, arbitral tribunals and national courts have conducted painstaking analyses of the conduct of the states concerned with respect to the succession issues arising in those specific disputes. For example, the identification by the High Court of Justice of England and Wales in the Gold Pool judgment of 2021 of the implied agreement of Canada and Kazakhstan in 1993 on the basis of a painstaking forensic analysis of their negotiations concerning the succession of Kazakhstan to the 1989 Soviet-Canadian Bilateral Investment Treaty. In returning to the classical conception of the law of state succession as a unitary field of general international law that existed before the codification projects of the International Law Commission, it is suggested that the next step in its doctrinal evolution will be a renewed willingness to apply general rules of succession to disputes in the absence of specific agreement by the states concerned. In modern jurisprudence, such as the arbitral decisions of the Eritrea Ethiopia Claims Commissions, the unwillingness of national courts and arbitral tribunals to evoke default rule general law has been motivated, above all, by a lack of comprehensive and close treatment of state practice in accessible form. In this respect, this effort is offered as a contribution to the development of the law of state succession, which, it is contended, is an integral and cohesive field of general international law grounded in a long and gradual process of evolution in state practice. An inevitability in a world in which territory has been very largely allocated, the coming of age of the law of state succession will mark another step in the maturity of international law to address one of the most profound and complex experiences to be faced by a state arising anywhere and everywhere in the world. Thank you.